Hello, everyone. So this week we are going to be revisiting the Johnny and Bob case that we did last week. And then we're going to kind of apply UCC to that because with kind of the new conditions in this case, it kind of changes the rules a little bit. And the UCC and common law can differ in some aspects. And so we're going to kind of evaluate it in that case. And so I'm going to start off by going through our facts that we had last week, just so we're kind of on the same page, and then go through kind of the new ones that were added in this week that kind of changed things a little bit, and then I will get into the questions. So I will get started. Johnny just received his driver's license and is excited to purchase a car. Johnny did not tell his parents he was going to take the exam or that he was going to purchase the car in the first place. He had been working for several years on his parents' farm and has saved $5,000, which he has kind of saved for the purchase of this car. He's been talking with Bob Jones, the owner of Bob's Used Cars, which is located in the neighboring county. Johnny suffers from significant health issues, which have limited his ability to visit his friends in surrounding towns, and so he's kind of excited to have his own car so he can go visit them and hang out. His parents are not aware that Johnny has been talking with Bob about the purchase of a car and would likely not give their permission to Johnny to purchase the car. As part of the conversation with Bob Jones, Johnny does not tell Bob his age and Bob does not ask, and they also do not discuss Johnny's health issues. Bob shows Johnny a used 2005 Mustang and tells Johnny that the car is the finest in the county and only has 25,000 miles. He tells him that it's a one-owner car and has never been in an accident. Bob has the sale price of $49.99 displayed on the Mustang, but tells Johnny that he will sell it to him for $4,500. Johnny tells Bob that he plans to use the car to run moonshine. Bob notices that Johnny is having trouble understanding the information. Bob is hearing about the car, but he doesn't follow up with Johnny to make sure that he understands. He's heard about Johnny's health conditions, but again, he feels like it doesn't involve him, so he doesn't ask Johnny about those. Johnny agrees to purchase the car for $4,500 cash and purchases the car on the spot. Bob does remind Johnny that the car is being sold as is where is, with no warranties implied or expressed. Johnny arrives home shortly after purchasing the car, much to the surprise of his parents. There we go. Johnny's mother goes online and finds that the car has had multiple owners, has been in multiple car accidents, and even suffered flood damage. Additionally, there is a question about the miles on the car. Johnny and his parents are scheduled to go on an extended vacation the next day, and they don't get back until after Johnny's birthday. When they return, Johnny and his parents take the car back to Bob's used car dealership and demand that Bob take the car back, essentially getting a refund. Bob refuses, stating the car was sold as is where is, and it's past Johnny's birthday anyway. So kind of the new things implemented this week. Johnny now has grown up and has his own car. He owns Johnny Jet Auto Resale Specialists, which is a company in Nebraska, kind of in the neighboring town or county to where Bob's used car sales are. And so he's now an adult, obviously, to have his own business, and so I don't think that he would go to his parents when he purchased the car. So there's a little bit of kind of loose ends, I guess, in terms of the facts and how they relate, and so I'm going to do the best that I can to kind of evaluate the new things with the UCC, the new rules that apply, and kind of all that. So here we go. The first kind of question: if Johnny Jet is not a minor and is the owner of Johnny Jet Auto Resale Specialists Nebraska Corporation, and as such, this is a sale between merchants for the sale of goods under UCC Article 2, state whether there is a proper offer, acceptance, and consideration for the UCC sales contract. So Article 2 of the UCC applies to transaction in goods. All states have held that Article 2 applies to a sales contract for the sale of goods. A sale consists of the passing of the title of goods from a seller to a buyer for a price. A merchant is defined as a person who deals in the goods of the kind involved in the transaction, or a person who by occupation holds him or herself as to having knowledge or skill peculiar to the goods involved in the transaction. So in this case, both would be considered merchants because you can reasonably assume that both are pretty well informed about cars and kind of that industry because they both have car dealerships. So kind of getting into the offer, acceptance, consideration, and all of that, a contract for the sale or lease of goods may be made in any manner sufficient to show agreement, including conduct by both parties that recognizes the existence of a contract. So in this case, we do have a contract, which is the bill of sale of a motor vehicle document. That was the document that was attached in the file for us. The document states what is being considered. That is the 2005 Mustang. It also states that it has 25,000 miles and 2 doors. And it goes into like the make, the model, the vehicle identification number, all those sorts of things. The offer to Johnny Jet Auto Resale Specialist is the car in exchange for $4,500. According to the contract, there is no warranties, expressed or implied, attached to the vehicle other than manufacturer warranties that may still be in effect. The contract also states that the purchaser has been given the opportunity to inspect the car and that the purchaser has accepted the condition that the car is in. And so that part right there goes back, if you remember, kind of in the first place, that he didn't know the car had damage, all those things that he didn't really know when we looked at this the first time. I think that all goes out the window right there because it says that he has accepted the condition that it is in, so we can't go back and say that, oh, he didn't know, because he also had, it says that he has inspected the car and accepted the condition that it is in. And so I think that all those things kind of relating to the first time we went through this go out the window because of that part of this new contract. And so I think that part is very important. The second page of this document that was attached states that, to the best of his knowledge, Bob Jones certifies that the odometer reading reflects the actual mileage of the vehicle. So that the odometer hasn't been tampered with, saying that it has 25,000 miles when it really has 80 or whatever. So he's saying that, yes, this odometer is correct. The car has 25,000 miles. So with all of that, we have a contract for the sale of this vehicle, although it is not signed by either individual. And so I'm not sure if that is supposed to be significant, or we're just to assume that when you purchase a car, you sign a contract. And so I'm going to assume that Johnny signed the contract when he purchases the car. And so I believe in this case, Johnny has accepted the vehicle because I'm going to, again, assume that he signed the contract when he paid the $4,500 to Bob when he purchased the car. The next part of our assignment state whether the goods have been identified sufficiently in the contract document and whether title has validly passed between Bob Jones Auto Sales and Johnny Jet Auto Resale Specialists. Excuse me. Provide support for your position by citing facts to back up my argument. So I believe that the car has been sufficiently identified in the contract. They have the make, the model, the year, vehicle identification number, the odometer reading, the body type. Those are all included in the contract. If there's to be anything missing, I think maybe the color should be included just for increased clarification. Because maybe Bob has 5 or 10 2005 Mustangs. I don't know if he does. It doesn't say. But just for increased clarification, I would say the color, maybe throw that on there too. But without that, we still have vehicle identification number, which ties specifically to that car. And so I think we have identified which car is being sold in this case. In addition, we know that the car is being sold, what the car is being sold for, who is selling to who. So Bob to Johnny for $4,500, and warranties that are going to be excluded or included in the sale of the car. And these are all required for the bill of sale of a motor vehicle, and they are included in the contract. And so I believe that everything is there for the title to pass from Bob to Johnny because of all of the specifics that are included in the contract. Identifying the car, who it's going to, for what price, all those things are included in the contract. Next, state what, if any, warranties apply to the above linked sales contract based on the facts, the sale language in the contract. So in this contract, it does not state who owns the car while it is being delivered to Johnny Jet Auto Resale. If I were Johnny, I would want that in writing just to kind of cover all loose ends, make sure there's no confusion. But it is not included in the contract in this case. And so in our book, it states that unless otherwise agreed upon, goods that are shipped via carrier are considered sent pursuant to a shipment contract. And so in a shipment contract, the seller ships the goods to the buyer via a common carrier. The seller is required to make the arrangements and deliver the goods, and title passes to the buyer at the time of shipment. And so when Bob ships it, like it just leaves Bob's place of business, it is technically Johnny's. Even though it is not at his place of business yet or in his possession, it is Johnny's. And so I don't know if there's any warranties that are covered with that. If Johnny would want something, he would have to talk to Bob about that. Oh, there's fireworks. So sorry about that. Just kind of caught me by surprise. So there is nothing. So Johnny owns it as it's being shipped. If he would want warranties, he would have to talk to Bob. Otherwise, Bob is not covering any, if there's any damage or anything like that, Bob is not covering that. So other than warranty during shipment, all the other warranties that would apply are the manufacturer warranties that still might be in effect. I believe that Bob clearly stated in the contract that he is providing no warranties to Johnny on the car. It is like specifically laid out that he is not doing any of that. And so I believe that there are no warranties on this car unless there are manufacturing warranties. And then if there would be any additional ones for the shipment. But it does not state that, so I don't believe that there are any warranties during shipment that would cover any damages to the car for Johnny in case of like an accident or anything like that. And so I believe that is it. That was kind of my analysis of the Johnny and Bob case, this time with UCC and merchant contracts and all of that, and how that kind of differs from common law. So there you go. Have a good one, everyone.